which I think it is difficult to attend a session, but what to do, the time fixed for lunch session only. Let me see as much as possible the interesting one, and of course with your interaction. Without that, it won't be interesting at all. So good afternoon all. I hope all are there.
Yes, good
Only the
afternoon.
names are appearing.
Yes.
Except me, no other videos are there. Okay, fine.
Yes, sir. Good afternoon.
Good.
Yes.
But at least by seeing somebody, at least I know somebody is there on the side.
Please.
Okay, good. See, today the topic, as you all know, that practical difficulties. I know all must be here. Liquidator must be an experienced liquidator by now. After 7-8 years of journey in the IBC code, practicing of IBC code. And the topic is that practical difficulties that in liquidation proceeding. So let's try to understand, at least from the participants now. Then I will share my practical difficulties, what I encountered in my assignments. From participants, at least let me know what do you feel as that as a real challenges that we face in liquidation proceeding as a liquidator. Any of your difficulties that you can share here, so that we can take up those topics and we can deliberate that also. I have my own topics and I will add this also, whatever you are sharing. So any other topic to share? Any other difficulties that you want to share? So everyone is comfortable, happy, there's no difficulties at all. Then we don't need a topic at all. You can share any of your experiences which you are facing in with the department or ex-promoters or COC or ACC. Any of your experience is there to share, or I can move on with my own presentation. You want me to run the presentation and move on? Anything else to share? Okay. I'll do one thing. I'll move on with my presentation. If you want, you stop me. If possible, you stop me. Okay. Otherwise, I will be with my speed. Okay. I thought I should not simply run the PPT, but what to do? You are leaving me with that option only. Let me run the PPT. Then we will see what is coming up. So for our discussion, based on our discussion, then we will see. We will discuss. Take it forward. I'll share my screen and I will share a few things on. See, before getting into this discussion of difficulties, I know most of you. I will be opening up your issues and other concerns when it's move on. When when session moves on, you will do that. Because I know there cannot be a liquidator without challenges. That I am sure. Suppose if you are not with the challenges, that means you are not practiced as liquidator. Because if your practice as liquidator or to handle the assignment as liquidator, you must have faced some difficulties. There is no doubt, because
this is true, sir.
Yeah,
this is true. We have not.
that's what I'm saying.
I'm speaking for myself. I have not experienced any liquidation proceeding as of now.
That's why I said very, very gently. I said no. If you are someone is going to say that no, I'm very happy and nothing I faced in the world, that means you are not practiced well. I should say that way only. Or you have not practiced enough. I have to say that way. Not even well. You have not practiced enough to get difficulties in liquidation process. If you practice enough, you will encounter all kind of difficulties. That they will put the stakeholders or everyone around us will put us in all difficulties as much as possible. Okay. Okay. Anyway, we will discuss one by one. I have a lot more to share. I think now I think in my previous thing, many new participants are there. I could see. Because generally, I used to see the regular participant, but this time, so it's good that I can share all of my experiences with all these new participants. See, before getting into the difficulties, what issues, whatever we faced, let's understand why this code and is really serving the purpose, why it has come. It's really serving or it served the purpose. Any view on that? Because it's too late to go into the why this code, all that. Getting into that discussion is not now. It's too late to discuss now, because now already we are into practice and we have handled enough. We would have handled enough matters. So now we would have understood the real purpose of the code. Is it really achieved? The purpose is really achieved by the government, or at least by professionals. The purpose of the law is achieved by professionals. Have they really enjoyed this particular practice as a IP? More particularly when they handle as a liquidator. When they handle IRP, RP is different experience. When you handle liquidator, is a different experience. Anyone in the participant, which is more challenging, whether as a RP or liquidator? Any idea? Something you can tell. So you don't want to vouch both. Both are struggle. Both not able, sir. Unmute yourself.
It depends on the assignment.
Sorry.
It depends on the assignment. It depends on the assignment.
Based on the
Whether
assignment.
it is, yes.
Okay. Okay.
If it is good, it may be for liquidation also, it may be for KIP also. If it is bad, it is work for all.
But both are challenging.
Both are challenging.
Good. So, but my question is that which is more challenging only? Actually speaking, I know both are challenging because code itself is a challenging one only. No doubt at all. Which one is more? I'm asking.
Definitely, liquidation is more challenging.
In what sense, sir?
Because sometimes the liquidation value is time and the liquidator has to repeatedly advertise, and it cannot be less than 10% of the liquidation value at a time. And once a time, it can be up to 25%. And
Okay.
repeatedly, advertisement has to be done in the newspaper, and there is no outcome.
Okay.
Because in
Yeah.
the practical value is something else, and but the value has been assigned in the liquidation is different.
No, all are process in the liquidation. No doubt.
Yeah.
The real challenge I'm asking, comparing to CRP.
To maintain the legal assets of the corporate data. Yeah. Because the liquidator has to manage the assets, and it has to pay to the security expenses, and no one is no SEC member is able to finance this cost. Maintenance is required.
Any other views, sir? Any other view?
Financially, it is also difficult.
Anyone else? Anyone else? Any other participants? Comparatively, which is more challenging, CRP or liquidation?
Sir, I am Sanjeev Rathi. Basically, if you see, liquidation is the second step, most of the cases. First, it is CIRP. So when we have exhausted the options of getting a resolution or sell it as a going concern, then if it doesn't happen, if everything fails, that is the last option, liquidation. So naturally, when you have exhausted everything, and by the time we come to the liquidation, most of the assets become very difficult are not saleable. Many times, even the suspended board is out. They are not interested.
Hmm.
You are not getting people. And liquidation, most of the time, and as of now, it is not even happening as a going concern.
Hmm.
Recently, notifications have come. So you are sealing piecemeal sale of assets.
Hmm.
In fact, the biggest challenge is you will not get your fees also.
Hmm. Okay, then that's all. We are finding difficulty in realizing the assets. There is no other aspects that we are facing difficulties. There's no other aspects that we encounter issues. Departments, ex-promoters, other stakeholders.
Yeah, by the time the liquidation happens, there will be a lot of litigation happening. A lot of stakeholders are there.
Hmm.
Most of the time, you will be spending in the NCLT or NCLAT or as it happens.
Is that only a time is sufficient for us
So
for liquidation, completion of liquidation?
No, sufficient time is not there, and every time the liquidator has to file an application for extension of time.
So
Okay.
time is sufficient if all the process, NCLT hearings, everything happens on time. Time is sufficient, but the way things are happening as of now, whether it is ARP or anything else, it is very sad to say it has become almost like any other law or any other code. See, I have cases which are going for 3 years and nothing is happening.
In fact, recently this week, day back only, Supreme Court has observed. I don't know how many of you have seen. They have observed. Honorable Supreme Court has observed that why tribunal became liability to the judiciary. I don't know. I've not gone into the case what has gone through, but only the headline I have seen it. So Supreme Court has said why tribunals become liability to the judiciary. It's a strong state from Honorable Supreme Court. I don't know. I have to read why that. What gave that impression to the Supreme Court? That. But as you said, it's
But the other courts are dealing properly. High Court or Supreme Court, there are no pending issue like in the NCLT.
mm, mm,
Whether it is court or NCLT, everywhere is pendency.
okay.
And time taken in cases are up to 20 years here. Normally 5 to 6 years is normal.
Okay.
How it can be said as a tribunal or burden? Every court is burden.
Fine. Anyway, well, let's discuss one by one, and if any further any issues or difficulties or any other concerns, whatever we will discuss. And after all, we are all practicing, and we should find answer by sharing our mutual experiences. Before getting into the practical side, let me brush up the theoretical side quickly so that it is easy for me to take you through uh, practical sides. Okay. And actually, if you see that the liquidation, the law says, certain law gives certain provisions. And when it is getting implemented and when it is practiced, and it is differently understood and getting practiced. So that how the gap gets created. So we have to see that how we are encounter and bridge that gap and do practice well. That's the become a bigger challenge. I'm saying what is there in the code and what is there in the practice. Between these two, there's a gap. Okay, that gap should be filled by a insolvency professional by his way of his by his what to say eminent or his experienced approach. That gap has to be filled. The gap will be less and more based on the capability of the person and based on the issue. issue size and complication of the issue. So, but anyhow, there is no alternate word to say that challenges are there. There is no other second thought on that. Let's see what are the challenges, how it can be managed, or how we should overcome those challenges and make sure that we are sailing through the process in accordance with the provisions of the code. So before taking you to practical side, as I was referring, let me take you through some theoretical side of it. Brush up the theoretical side, then take you to a practical side. Then you can also relate, you can connect yourself. Yeah, I have so many slides to present. Almost I've got 6-7 slides to present. But let me see whether all this can be presented to you. For sure, I will share the slides, but based on the time availability, I will see how it can be. I can justify the. Wait, just a moment. Okay. Now, I'll just take you through the basics. Then probably one by one, when we start discussing issues, I will take you through one by one because I have all aspects to cover. Difficulties from department side and sale as a going concern and many more I have. Then issues from promoters and COC, SEC, all we will discuss. I will take you through one by one. Suppose you feel that some other issue which I am not covering or skipping, you can also remind me so that I will include those issues also for discussion. Okay. Now, taking you through to basics. See, when I recollect when the law came in the year 2017, because it was literally we all were in the impression that we are getting some new code which is really going to address the entire financial failures of the country. Okay, that's what the real understanding that we were having at the time when the code was introduced. Of course, the introduction of the NCLT from 1st December 2016. After that, when code has came into force, actually speaking, 2017 May, and when the NCLT started delivering their orders under Companies Act, then the IBC was introduced, and it was also given as an additional responsibility to NCLT. And the NCLT started taking care of the both Companies Act and Insolvency Bankruptcy Code. Okay. Now, going forward, means when day was passing, what was happening, really speaking, the insolvency bankruptcy, because of the complications, the cases of insolvency and bankruptcy code literally took a front seat, and the matters and the Companies Act took back seat because of the complications, nature of the complications, and volume and money involved and seriousness, all that matters, which really put the NCLT completely to give their more attention to IBC. Then too, they are not able to see that everything is getting disposed quickly. That's the reason I was referring some remarks also given by Honorable Supreme Court recently. But we'll keep it apart. But let's have a discussion on how things are moving on in practice side. Leave it all judiciary because they are doing their duty within their limitation. They are doing it. But of course, that also slowing down the process. No doubt at all. The liquidation process is getting slowed down because of the slow, or to say that the not quick disposal by courts. That also is another important reason for slowing down the process. The liquidation process getting more time. All is there, but still we'll give our best. Let's see. And now really speaking, after the period of 2017, now almost it's 8 years. Okay, 8 years and approaching the ninth year also. So now, how the code? What is the real benefit that everyone has achieved? The country as a whole, the government, the stakeholder, as a professional. If you look at the real benefit is practice area is got increased because of number of disputes, okay, number of issues, number of complications. Practice side has become really good, no doubt at all. People who are focusing more on practice side on NCLT, they really enjoyed. Otherwise, really speaking, most of challenges are new challenges have come up because the day when winding up under Companies Act, not this level challenges, the liquidator and the Companies Act has encountered. The challenges which today the liquidators under Insolvency Bankruptcy Code, what they are encountering, all those challenges really was not encountered by that level by liquidator under Companies Act, whether it is 1956 or 2013. The reason being the liquidator were part of the High Court under the 1956 Act. Unfortunately, here the liquidator are not part of the High Court, but part of the, it's a court officer. It's deemed as a court officer to limited extent, and of course, who are authorized to do execute their power, who is empowered to carry out their powers by virtue of the directions of the NCLT under regulation. As you all know that section 35 of the Insolvency Bankruptcy Code defines what are the roles and responsibility of the liquidator, and liquidator is executing their powers. But as an individual person, without wearing the cloth of court, because the liquidator under the Companies Act 1956 and 2013, they are wearing the cloth of High Court because they are part of the judiciary. High Court, they falls under the judiciary and they falls under the within the ambit of the High Court jurisdiction. So they enjoyed that privilege and recognition. Today, that real privilege is not there. For liquid, though, there is a protection given the IBC code, all it's there, and the overriding provision 238 is there, and we have a protection under the code, all it is there, but still, the liquidator are not really enjoying the real privilege what the liquidator and the Companies Act they were enjoying as officers of High Court, what they were enjoying. The same is not because the moment we say High Court, it is a constitutional court. Okay, so they enjoy really that comfort. But here the tribunal is constituted by the ministry. So we, to some extent, enjoy the comfort whatever we could enjoy by being an officer of the tribunal, means the court, not to the level of the Honorable High Court liquidator who is coming under the jurisdiction of Honorable High Court. So this itself is what to say, the real cause and the starting point, I'm saying. I would say that it's a starting point for the liquidator facing the troubles today. If at all we are facing troubles, there are provisions which still to be fine-tuned, no doubt. I will take you through those provisions also. What are to be fine-tuned to make sure that the liquidator under the Insolvency Bankruptcy Code can to efficiently and effectively to perform. Okay, and certain recognition also is required in addition to the provision what is uttered, so that the liquidator can really perform well and prove themselves. Okay. So Insolvency Bankruptcy Code, as you all know that this is the subsumed Presidential Insolvency Act and Provincial Insolvency Act. Of course, few provisions of Companies Act also has been subsumed. The BFR powers are subsumed in the Insolvency Bankruptcy Code. As you all know that right from section, that there is 10 sections are given to that, whereby the Companies Act provisions are completely not only the Companies Act. I'm saying section 255. I'm saying, okay, the entire gamut of laws which was going against the provisions of Companies Act has been fine-tuned. Means going against the provisions of the code has been fine-tuned to make sure every provisions are fall within the ambit of the code. See, that is a real benefit that we get, but still more it has to be fine-tuned. If you see the real benefit of the code, to take it from right from, if you see 240, I think I'll show you there in the thing, right from 245 to 255. Not only that, there's a transitional provision 244 that also is important. Anyway, I'll take you through all that in the code itself, so that you all can see what I could see in the book. You can see in the screen itself, and what is the impact that it has made. All that we will discuss. So basically, the code is just to government wanted to ensure that this code is introduced as a real benefit to arrest the financial failures or give solution to the financial failures of the country. This is the real purpose of the code, because you all know that there is only a legislation called Civil Procedure Code earlier. Now, of course, BNS, BN, BNNS, BNSS, BNS, all that has come. But actually, there was a code, Civil Procedure Code and Criminal Procedure Code, and the Indian Penal Code. After that, we could see the fourth one in our country. Well, when the Insolvency Bankruptcy Code got introduced, the fourth code was Insolvency Bankruptcy Code. Why it has to be the code? Because it is above the law, means above the act. It should not be seen as just an act. That is the real purpose why this Insolvency Bankruptcy Code has been introduced as a code, not as an act. So problem is here, whether it is a stakeholder or government, nobody want to understand actually, purposefully or I don't know, by ignorantly or purposely, I don't know. But they are not understanding why this is introduced as a code. Why not an act? There's a Companies Act 2013 is there, and there's Income Tax Act is there, and GST is there. Everything has been introduced as an act, not as a code. Then why this particular piece of legislation alone should be introduced as a code? Because there is a real purpose behind it. The reason being, this is to arrest the financial failure. This is not to regulate any particular, like Companies Act regulate the companies. The Foreign Exchange Management Act, it regulates the foreign exchange transactions. And if you see any other act for this matter, that act is getting enacted to regulate that particular segment. Okay, but here this particular piece of legislation is not to regulate anything, any particular segment. This particular code is enacted to take care of the entire financial failures of the country, whether it is an individual or whether it is a corporate. So that's the reason it's been enacted as a code, not as an act. But here, actually speaking, time and again as a liquidator, every now and then we are forced to remind to the public, stakeholder, government, and everyone, saying that this is a code, please understand this, however, overriding effect, 238 section is there, and even Supreme Court has also confirmed it. And all that time and again, we are unfortunately as a liquidator or resolution professional, time and again, we are put to remind to the stakeholders, government, even sometimes courts, that this is a code, this override everything, as if nobody knows. It is a law, it is a code. Everyone has to understand that way only. It's not that somebody has to teach or make them to follow. But unfortunately, the insolvency professionals face these challenges everywhere to make them to understand, to make them to understand, to realize that this law is above other laws. This particular code is above other law. So particularly, the struggle starts there. Actually speaking, the struggle starts there. Then, and every issues when they are coming up, we are put to face it, and we are encountering all these issues. And again, we are making them to understand the code. It's not just an app, it is a code. But anyway, our struggle continues. Almost more last 7, 8 years, we are facing the same struggle. And even today, we are educating or we are telling whether it's a government or stakeholder, saying that no, this is a code, this overrides all the provisions. But conveniently, people are ignoring, stakeholders and governments are ignoring. Conveniently, they keep doing what they are doing. And again, the RP and liquidator has to make sure that they are fighting and ensuring the compliance of the code is upheld. So that becomes the order of the day for the resolution professional and liquidator to make sure others, whether it's a government or stakeholder for this purpose, others are complying the regular, are following the code, at least not disturbing the code. Okay, that becomes our prerogative and become day in day out responsibility of liquidator. More than focusing on managing the show of the company, more times goes on explaining importance of the code and provisions, then and we encounter all that issues, as a byproduct to the practice. Fine. Now coming to the code, I've just quickly brush up the provisions of the code just to recollect only. Not I will not take too much time. These are the basic concept. I'm not here to explain everything. Just to brush up quickly, then I will move on to the practical side of it. Okay. We all know financial creditor and operation creditor. Wherever you have doubt, you can stop me. We'll deliberate and move on. Okay, and board instances, these are the basic definitions which we have seen, and now our limits have been increased. Then all these 14 days, all that, now more clarity has come. Now they were saying directly, then and whatever the timeline is given to the NCLT was considered as a directory, then whatever the timeline given to the insolvency profession, the code are mandatory. This is how the things have settled. And of course, recently also, one of the Supreme Court judgment I could see, recent judgment. Of course, it's not connected to that, so I am not quoting that name of the thing. But recently, Supreme Court observed that stating that the role of the NCLT is to see whether, just 2 days back that has got reported. Okay, Honorable Supreme Court has said the role of NCLT is just to see that whether there is a default, default or failure. And in fact, openly there's a remark by Honorable Supreme Court stating that the NCLT should not get into the recovery mode, means giving a solution for recovery. And the remarks given by Honorable Supreme Court is that it is the duty of the NCLT just to see that, well, there is a default and failure. If they are satisfied and with the existence of the element of default and failure, it is the duty of the NCLT to admit. Nothing more than that. This is what the remarks recently given by Honorable Supreme Court. But because the NCLT started, they are getting into more detail into the every cases, whereby they are trying to give, of course, they are out of their out of their experiences, or they wanted to help a company. But what Supreme Court says, NCLT, is that just do your duty, need not to help. That's what the recent remarks given by Honorable Supreme Court, that need not to go into deep of the case and find out whether debt is legally, how it can be settled. That's not the duty of the NCLT. This is what the recent remarks by the Honorable Supreme Court. So therefore, the law also provide, the code also provide the same thing only. It only says that whether the NCLT has to see whether default has occurred or not, that application is complete or not, and whoever is getting appointed as a IRP, there should not be anything. This is how the NCLT has to see. More than that, they need not to see. See, this is the reason why NCLTs are not getting time. why, as one of our friend was saying that more time is goes in the proceedings before NCLT itself. One of our friend was sharing that. Is it true? The statement is true because most of the time is going on in the liquidation, whether it is a CRP or liquidation. Most of the time goes in the proceeding itself. So why? Because so many of multiplication of litigations and the disposal also is getting delayed. Oh, that's the reason why disposal is getting delayed, because the NCLT is going in deep of the subject or deep of the case, rather stopping where they have to stop. See, this is what the Honorable Supreme Court also has passed a remark that they have to stop just by seeing whether default exists or not, and just admit the case and move on. That's all. If they stop there, they get lot of times to deal with other cases. When they go into deep of into the every case and start mediating or start start finding out way to settle the matters. Many of the matter I could see that they are trying to give some solutions or find some solution to settle the matter. This is what the recent remarks also says that don't try to settle the matter. That's not your role actually under the code. The code says either to admit or reject, to commence a CR, not to find out the way to settle. So if that way it happens, then probably disposal will be fast. Then we have to, our time also will be saved in the proceedings. So I think hopefully going forward, I don't know. Let's see. Let's wait and see. And operation data, as you all know, that we need to serve a demand notice and initiation CRP. All this is a routine thing. You must be knowing all this. These are the things which I was telling, what I was explaining to you. These are the same thing, what I was saying. So, so initiation of CRP, then rejection 14 days, all this is a very initial stage. So these are the, moratorium and benefits what during CRP, the moratorium is applied and the public announcement is given. All this is routine formality. Managing affairs of the company. Here it is very important to know. This only I keep telling now and then in every lectures, not even lectures, even in my representation to government department in my own cases. Okay, when they want government want to file liquidator all returns whatever in India, means whatever the returns that that has to be done under the laws of the country. They wanted the liquidator to file all the returns in the law whatever in the country. So I don't know, but law doesn't provide for. Actually, the Insolvency Bankruptcy Code does not give that authority or that role or power to the liquidator, but government authority they wanted, because they only know that. They only know to give that kind of feedback or response only. They only know give whether they are liquidator, director, or whoever it is, they don't bother. They say that you file return, you do this, you do that. They never understand the company and the liquidation and all. They always see very positively that company is running company only. For their own benefit, every government department see as a running company only. And they don't want to understand what is applicable to liquidation company under liquidation. Because better to understand as a running company, as if a company is a running company, so that it makes the job easy. Because they need not to worry too much struggle to understand what liquidation company supposed to do under the law. That they need not to struggle to understand. So for that matter, they make every resolution professional, liquidator. They wanted liquidator to file all the returns. They wanted liquidator to do everything, whatever should be done by the managing director of the company when the company is in operation. Whatever the managing director ought to have done. Same thing they wanted the liquidator also to do that, because they don't want to see company liquidation differently. They want to see a company only, not under liquidation, not under in operation. They don't want to, no government department want to understand that. They are handling all liquidation company as a routine company, normal company. Okay. And wanted liquidator to do the function of the clerk, accountant, and vice president, GM, director, MD. All those functions they wanted a liquidator to do. This is a practical difficulty which really I understand from few of our friends when they are sharing their thoughts on the matters, whatever they are handling. Even my own experience, I also encounter these kind of things where government department insists. Here, if you see, the law makes it very clear. When it is the IRP and RP only, it becomes the responsibility of managing the affairs is given to the insolvency professional when insolvency professional is acting as IRP and RP, not as a liquidator. But I don't know, conveniently, all stakeholder, government, everybody is conveniently forgetting this particular fact, okay, or legal position, and they wanted everything, whatever the IRP, RP were doing, they wanted the liquidator also to do the same thing. They don't want to understand the difference between IRP, RP and liquidator. They want to understand all are same so that their job become easy. The government job become easy. Whatever the form A, B, C, D, some name form, if it is filed, they'll go there with their own checklist and it makes their job easy. They don't want to understand and give a different status to company under liquidation. Okay, because all the more it is difficult. No, law is not that clear. They don't want to apply their mind and struggle to understand the law, when it is not clear. So they are following the same thing. So they wanted liquidator also to make sure that whatever the IRP, RP were doing, same the liquidator also. Every department and stakeholders wanted to do that. So during the IRP tenure, the IRP has vested with the power of managing of affairs, powers of the board of directors are suspended. Here, powers of the board of directors suspended. Duties are suspended. Duty is still there. I don't know. Nobody is worried about it. Any idea on that? Do you have any idea on that? Whether duties is suspended or only powers are suspended, or both are one and the same? Is there any difference between the two? Powers and duties of directors? You don't find any difference? That means even duties of the directors are also suspended? But the court says only the powers are suspended. I really fail to understand. Our fraternity also is keeping quiet. How now our participants are quiet? Same way our entire fraternity keeping quiet. And who has to voice out also, nobody voiced out, and court also never questioned this. I don't know what's going on in this, because the court says it's only the power of board of directors is suspended, but they have a different duties given under the Companies Act. Why it is not questioned at all? But here, liquidator, as I was referring, the entire government and stakeholders wanted the liquidator to do everything under the sky. In fact, they never think liquidator as a human being or man or woman. Okay, they think liquidator a different species that has come into the world, and coordination of the God, that they know everything. They should supposed to know everything and supposed to handle everything. They think that way. Okay, they are incarnation of the God, liquidator and IRP, RP. Conveniently, they think that way. Okay, for their own convenience, they think IRP, RP, liquidator are incarnation of some God. They know everything. They're supposed to know everything. They know handle. They can handle without money also. They can handle the entire company, which crores and crores of the by spending crores and crores of money, the management would have handled the company, handled the affairs of the company, managed the company. But this incarnation called liquidator should handle without money, because they think it that way only. because IBC code is nothing but a god. The liquidator is kind of incarnation of God who don't require any money to manage at all. Everything happens by magic, and nobody will be questioned also. Nobody in the court also will be questioned how a man or woman who is acting as a RP, ARP or liquidator without money will manage. Of course, there's a provision introduced in regulation 2A which says there's no liquidator, fund liquidity. The security creditor has to contribute. I don't know. Here the participants are only have to confirm. Are you getting really fund? I am not getting fund. I don't know. You keep quiet like this. Don't worry, nothing will change. We will struggle silently. We will conduct seminar like this, speak, and we'll close and go. And struggle in the background. And the bankers will enjoy at the cost of RP, IRP, and liquidator. Even they are going to get the power to even to remove the liquidator. That power they got through SEC also. And there is a substitute, just like a COC. This SEC also become going to be another COC under liquidation going forward. Once the law, whatever the amendments pending to be introduced, once it is introduced, that it will be, just a moment. I think some technical fault. Okay. So, so that's what I'm saying. So what I'm trying to say here, as a liquidator, the stakeholder should understand. The stakeholder should understand what they're supposed to do, and as a liquidator, what a person supposed to do. The government should understand as a liquidator what they're supposed to do, what IRP they're supposed to do, what RP they're supposed to do. Here, the powers of board of directors are suspended, and they are really enjoying the life. All ex-director and promoters are enjoying life. Is it not? Will you agree my point? No? They are also struggling without company. They are also struggling without company, right? If the company is there, furthermore, they can do something on the company. Now they are not able to do anything. So they are also struggling. That's how the stakeholders and everybody believes that the promoters are also struggling. After all, they are not. But problem is then why this situation has arisen? Whose fault? There is no fault at promoter. There is no fault at with the bank who has lent the money, who lent the money and kept quiet. They are not bothered at all how the money is spent and done. I don't know whose fault. But today, if liquidator fails in filing one single form, he is completely, he'll be at soup. The government and everybody will make sure that everything is done one single form. Here, the promoters and the management of the company that who has done a default of 1,000 crores, 10,000 crores, they are free now after giving to that incarnation of the God called IRP, RP, and liquidator, who knows everything, who's supposed to know everything. Okay, and who's supposed to know everything, and who's supposed to take care of everything irrespective of any situation. Okay, irrespective of any situation, irrespective of all kind of non-cooperation. Okay, because they are incarnation of God. I was telling they don't need any cooperation at all. They can still able to handle. That's how the world think. Okay, that we have to really come out and say the practical difficulty what we are facing. Problem with us is that only. We are always very generous people. We never discuss anything. We never tell our issues out. We face within four walls in our cabin and scream inside and say that nothing is happening outside. No changes are coming out. How changes will come out? When you voice out, only changes will come out. Here, when I was raising a question to you, whether are you any facing difficulty, you all keep quiet. That means there is no difficulty. Government will think that way only. Our institute also will feel that, yeah, see, all the insolvency professionals are so happy. No difficulties at all they are facing. So that's why they are not opening their mouth at all. Here I know every insolvency professional, every IRP, RP and liquidator will be screaming. How they may be screaming, because with my own practical experience, I know how every person must be screaming, except one or two who may be blessed to handle it properly. That exceptional and all, I'm not talking. I'm not talking that exceptional. Okay, they are real incarnation of God, because they are blessed that way without getting into the problem. Few one or two would have done properly and would have enjoyed the whole show, entire process. They would have enjoyed, done it, and would have uh, completed the assignment also. I'm not denying it. They are all exceptions, but most of the thing which I heard outside world and in my own experience, very challenging only. Okay, no doubt at all. We need much more cooperation and support. Even as I was referring, powers of board of directors, and here this only I was telling. Here it very clearly says powers. In fact, I wanted to show exactly the language what it is. Just a moment. How many of you have seen it or not? What exactly the language is given? See here, if you see that, the moratorium is declared. Okay. After declaration of moratorium, what happened? All this is there that should not be done, and there should not be any case, any suit or pending suit should be initiated, and all surface should be. Just a moment. I'll put it this way. Here, duties of insolvency professionals. Okay. I wanted to show this. So during the IRP, okay, the insolvency professional is given certain duties. Okay. What are those duties? Are collecting details, all that is given. Same way, whether directors have duties or not. This is my question. Because under Companies Act, they are given certain duties. I don't know how many of you has read that provision. I'll show you the Companies Act. Because we are very generous actually. We don't want to question anyone. We don't want to escalate anything. So same way, when the question comes, duties of RP, IRP and liquidator, everyone is there to question and everyone is there to find fault on IRP, RP, liquidator. But same duties are given to even directors. Why that is not really concerned? Or no one has raised concern on that, and courts are also not worried about it, and stakeholders also not worried about it. Let me take you to that. Okay, see what is that? So I was showing duties of IRP. Can anyone say that a duty is, if not complied with by IRP, what is the consequences of it? Suppose IRP fails to do his duty, what is the consequences of it? Can anyone say? You are all practicing IRP and RP and liquidator. Just tell me what is the consequence of it? Can we fail to do the duty as IRP? Suppose we are not collecting the detail of it. We are not collating. Suppose we are not constituting the committee of creditor. What is the repercussion? Can anyone say? How many? 22 is there. Out of 22, no one is there to answer. What is the replication of it? Any fine penalty? Suppose the duty is not carried out by IRP. Can anyone say? You can
It
unmute
is
and say.
professional misconduct then.
Sorry? Sorry?
If we are not performing duty
Hmm.
without any proper reason, then it may be a misconduct.
Hmm.
And we may be reported to IBVI by NCLT or other person.
Hmm.
Complaint may be happened. But if there is a solid reason that due to this or that reason we could not perform it, then it may be a proper excuse.
Okay. See, when we file as a IRP, as you said, there is a replication on that. Correct?
Yes,
There's a replication on that. Same thing is there for director. Why we are all not bothered about subject to the provisions of the Companies Act, provisions of this act, a director of company shall act in accordance with the articles. This is the duties of directors. A director of company shall act in good faith in order to promote object. Director of company shall exercise duties with due exercise, care, skill, diligence. A director of company shall not involve in a situation in which he may have direct, indirect interest. Director shall not of company shall not attempt to achieve any undue gain, advantage, either himself or relative. Shall not assign his office. Director shall, if a director company contravenes the provision of this, such director shall be punishable with fine, shall not be less than 1 lakhs. Whether in this 8 years, any single director has been prosecuted that he has not done his duty.
to my knowledge, no.
No, that's what I'm asking. That's why. How then whether the government does not know this provision or stakeholder need no, they don't want to enforce this provision, or court they don't want to enforce this provision, or no directors are falling under this provision.
Sir, first thing is there should be any complaint against the director, and if someone is not complaining against the director,
No,
it is usually
when
not
company comes
arising.
into when company comes into CARP and liquidation, the director, see here if you see, when company comes into CRP or liquidation, director powers alone is suspended, right? Not duty.
Yes, yes,
Agree with me.
yes.
My point is very simple. I'm
Power
not
are suspended only.
exactly. It's only a power is suspended. No, not the director. Duties are suspended.
Agree, sir.
Why they are spared? I'm asking. I'm asking why they are spared. Why directors are spared? Why export promoters are spared? Because they're actually speaking, their powers alone
Sir,
are.
a question is who will complain if we are seeking cooperation from director to run our CIRP process or liquidation process. We usually cannot or say we will not complain because we are seeking cooperation, and without their cooperation and information or other thing, we could not successfully run the CIRP process, and we always seek
See,
their cooperation. Even 19 application before NCLT for the seeking cooperation.
mm,
But if we are complaining against the director,
mm,
then question of cooperation is, I do not think it is almost impossible.
mm. So purposefully, you are telling we are adjusting.
Yes,
We are adjusting.
yes, simply, sir.
Okay. Mm. So, but the court at least see, it's okay, fine. As a professional, we need their support. But I'm saying when duties are still on, when duties are
Yes,
still
it is
on,
on.
it is when the duties are still on. But have you heard any of the directors are pulled in during the CRP during the liquidation?
No, no.
That's why I'm asking. See here, section 17 very clearly says the management of affairs only is vested. The management affairs alone is vested with the IRP and continues to vest with the RP. It only say management, not even say you are the owner of it. IRP, RP is not the owner of the company. IRP, RP is not the CEO of the company. They are just given a limited power, not even a power, responsibility. Okay? They are only given a limited responsibility to manage the affairs of the company. So that means that, so when you use the word management of the affairs, means you are temporarily managing the affairs. Correct? Temporarily we are managing the affairs.
Yes.
That means again it may go back or it may have a different this thing. That's the whole point. When managing the affairs, the law says the power of board of directors be suspended. The law says because two persons should not manage parallelly. Two persons should not be, they should not manage parallelly, right?
Right.
That is the reason power alone is suspended. The duty is not suspended actually. But I don't know why no directors are now given a responsibility. In fact, they are not even giving detail in many cases. Okay, they are not even giving full details what they are supposed to give. Many of the Section 19 application is pending before Honorable NCLT, right? Many of even the participants here would have filed also, even under the liquidation, for seeking their cooperation for details. But still now, any single directions or penalty or any fine is levied against directors for non-providing the detail. Of course, they are directed to provide detail, but still I'm saying for the non-cooperation. No, I'm just saying, are they penalized for non-cooperation? But they're supposed to be there along with the IRP, RP and liquidator during the entire process, because the duty is still live. Only the powers are suspended. Correct? Duties are still live. Then how they are spared? I really don't know. Because here, if you see the officers managers of the corporation shall report to IRP. Why? Because the IRP is given a power of managing affairs. So when IRP manage the affairs, naturally the officers should report to him. That's the idea. But the duty is given to director. Duty is not taken away from director. Duty is very much is given to the director as per the article. Liquidator is not bound by the articles of the company. Please understand. Directors are bound by articles of the company. Liquidator are bound by the provisions of the code only. Not bound by the articles of the company. But directors are bound by the articles of company. That means during CERP, though the role is given for the RP to run the company, to manage the affairs of the company, still the duty of complying the entire provisions of article of association is lies with the director. Is it happening that way? Is it happening? Here the question comes only to the RP that why this is not happen, why that is not happen, why even there is no cooperation from director. Then of course few cases I heard also. Why there is no cooperation? No, he will give. He's simply the director's management says no, I don't have that detail. With that the RP liquidator should manage. If you manage somehow you manage and come out with the information memoranda. If you manage and somehow come out with the e-action, then the directors and the promoters take shelter that how could without detail he has come out with the IM and come out with the e-action. They take shelter in that also. Suppose in spite of that, with a lot of difficulties, our IRP, RP friends and liquidator friends come out with the IM, information memoranda and e-action of property during liquidation. Then how could they are coming out? Then also they take shelter under that. That means they have a detail only. Without detail, they cannot come out. Then they wait for it. Then the RP, IRP and liquidator will be at fault for not carrying out their responsibility. So that's what I'm asking. What really exactly and the real responsibility and duties given to the liquidator, and what is the real duties of the director. Whether the directors still have duties or not, I don't think so. I don't think anyone has realized this way. Any stakeholder, or I don't know whether it is really realized. This legal position is really working or recognized or vouched by stakeholders. I don't know. Nobody knows. And because nobody questions them, actually speaking, except the IRP, RP, and liquidator who seek NCLT support under Section 19 to seek the cooperation of the director ex-promoter for details, except that nobody is troubling them, right? Except a few cases are getting filed, whatever mishap took place during the company when it was in operation. That only few directors matters are there. Then too many cases are filed against the RP and liquidator only. Then too, not even a directors. Only few cases are that, like check bounce, all that only criminal matters are getting filed against them. All other cases are filed against company corporate debtor and liquidator and RP only. In the whole history of the company, suppose the company was functioning 40-50 years, the whole history of the company, more than the managing director, CEO name reflected in the court cases. Now the RP and liquidator names only reflected. Never MD names got reflected when they are not doing affairs of the company, when they were not managing properly the affairs of the company. But when RP and liquidator step into the shoes to make sure whatever the mishappening or whatever the mistake carried out done by the earlier management, now IRP RP faces a lot of cases, issues, and their name only get flashed as if they only invested money, they only took loan from the bank. Their name only versus so and so, X versus so and so company, Y versus so and so company. Here that man has come to resolve the company. He is not there to fight he is not there to fight with the stakeholders. The RP and IRP, RP liquidator is given a task of resolving the company and bring back the company, not to the fight with all the stakeholders and all fictitious cases which is getting filed, and not to file with the department just for the flimsy reason of not filing return, not giving this, not furnishing detail, not giving information, all flimsy ground. So many cases are getting filed against RP, IRP, and liquidator. Is it not? I'm telling the truth or not? Are you not facing the problems? Are you not facing the cases again which is filed against you by department stakeholders? You are facing only, no? Silently, everyone is handling that without voicing out. So that's the reason these kind of sessions are organized. Because enough we have gone through the provisions. How to handle it, how to deal with the difficulties, that only we need to understand. Because the provisions alone is not helping us to deal with the issues that we are coming across, a difficulty that we are coming across. How many of you got notice from income tax and GST? None of you got? None of you got notice from income tax and GST?
Yes, sir, we are getting.
We
All are
get,
getting almost.
why you are to get? I'm asking why you are to get. You are not promoter, you are not an investor. You are not an investor. You are not a promoter. You are not a director. You are not a MD who ran the company, who managed the affairs of the company. Why you are there? Why we are there in the company? We are there to resolve the issues. We are there to resolve the issues or to answer the government departments or face the litigations or cases with the government department stakeholders. What is the purpose that we are getting engaged as a court officer? In fact, it's only a tag only is given as a court officer. I really don't know whether we are getting that privilege. You all should confirm it. Are we getting that privilege? The law gives that we are under supervision of the NCLT, we are functioning as officer. Okay, that law says that under supervision of the NCLT, the liquidator, because there is a order which speaks about it, that we are executing our power, exercising our power based on order of the NCLT. But are we really recognized or that way by the stakeholder and government? Then how could cases are filed? Just answer one question to me, okay? Or you keep silent for that also. I have no problem. Because whatever I know, I'm here to pour it. You take it or you take this opportunity to develop your case or find solution or keep quiet as usual. But this is what I wanted to say. When a matter comes, X versus ABC company, the X is nothing but a court officer. The law says he is a court officer because he is exercising his role by virtue of an order passed by an authority, means a judicial authority, okay, called NCLT, adjudicating authority, called NCLT. So the X is representing NCLT. When the name of X reflected in a criminal court, when the name of X is reflected in a civil court, when name of X is reflected in a high court, is that X is represented by NCLT or X is in a personal capacity? Can anyone answer this? Because warrant is issued, I heard few of our liquidator friends have got warrant from criminal court as A1. Do you know that A1? Accused one on behalf of corporate debtor. My question here is whether the A1 is a liquidator or RP or the authority whom they are representing. Who is A1 here? Just share your views. You are all RPs only or IRPs only or insolvency professions only, no? Share your views on that. Who is that? Whether the cases are filed against the RP, IRP and liquidator in their individual capacity or representative of the NCLT.
Mostly in representative capacity only, not the individual capacity.
Is that A1? Then can the A1 NCLT be deemed as a A1 in that case?
I understand your point and it is helpful.
Very simple. That's a very simple. Whether A1 is that X who is representing NCLT, that means he is representing AB NCLT. It's not his individual capacity. The X, whether it's RP, IRP or liquidator, is only a representative. He is not for his individual capacity, he is doing anything. Because he is only executing an order of the court. Is it not? He is only exercising the powers given, role given by an order of the court, means NCLT. He is not doing anything on his own. Are you doing anything on your own? Any of the participants who are here, are you doing anything of your own without direction, without having a power given by the court?
No.
No, sir.
Then how could your name is appearing X with a so and so company? That itself is wrong. Please go and see in other countries. Please go and see matters which are reflected in other countries. That's why I'm saying here, we all people only know how to be in silent and struggle on our own. Because we are groomed that way. Nothing we should expose out. We have to be silent. We should unnecessarily why to put ourselves before. We should not be forerunner. We should be behind. Somebody step in. If they get through, then we'll also step in. This is the approach everyone has got. Problem that only. That's why we are facing all the problems. We don't want to be a forerunner. We don't want to expose any of our points. We don't want to even share any of our point. We don't want to share even our experience also, struggle also. Because why to share? Let us be silent. If somebody shares, we will take up silently and enjoy it. No, enjoy, then enjoy, silently enjoy. Enjoy silently the solution also. Enjoy silently the struggle also. Then you won't get answer at all. That's why name is getting reflected. X versus ABC company, as if X is a criminal. It's okay, at least it is getting listed in the NCLT, it is fine. Because it is before the forum whom we are representing. If same is appearing in the criminal court, is it okay? Yeah, many of the liquidator, many of the RPs names are getting reflected in the criminal courts. A1, A2, A3 and all I'm seeing. Is it correct? That only I'm asking. Is it correct?
No, the practice is wrong.
We are all happy with that. Say, you people are keeping quiet. No, that means you are all happy only. That means I have to take it that way only. You are all happy only by being accused, by listing ourselves as accused in the case. We are not so. We are not. Then we have to expose only. We have to tell only. We have to object only. We have to say that, we are only representing. How could you can say that we are the X? In all foreign countries, many of the foreign countries, I have seen the cases. Many of the foreign countries, only name never come in any of the insolvency and liquidation cases. It only carries liquidator versus ABC company. It only carries liquidator versus ABC company. I never seen, you go and search in the Google and see in foreign companies, Singapore and many other companies. You can't see the name of the person. Because the person is not here associated at all here. He is only executing the role. But here, not even they are not even displaying as a liquidator or RP. I am seeing many of the listing is coming. Directly name only is coming. X name is coming. X versus ABC company. My God, in a criminal court, that too A1, A2, A3, accused 1, accused 2, accused 3. Will you be happy by seeing your name? Then hyphen, accused 2, accused 3. Will you be happy? Oh, we have to rise up. We have to raise voice. We have to say that it is not our duty. There is a duty casted upon to the director. We are here just to temporarily manage the show. Just to manage the show, nothing more. And make sure that the company is resolved. Finding a solution. Finding asset maximization. And suppose there is no solution, there is no resolution coming, then next level, you have to go to the next level. In fact, you can go and see the object of the code. Object of the code does not speak about liquidation at all. How many of you have seen the object of the code?
Right.
Just go and see the code, object of the code. See what code says. An act to consolidate amend law relating to reorganization. Sorry? See, an act to consolidate amend the laws related to reorganization, insolvency resolution of corporate person, partnership in a time-bound manner. Time really followed like anything. 7 years time is followed instead of 1 year. Time-bound manner for maximization of value of assets. Already the value is completely destroyed before it is coming to the hands of the RP and liquidator. But they should make sure that value is maximized. Okay. To promote entrepreneurship, that too without cooperation. That's very important. The ex-promoter will not share the details of the asset where it is. He will not share the details of the ownership documents of the asset. He will not share the other details of the corporate data. But RP liquidator should make sure they are maximizing the assets. Okay. In spite of non-cooperation from all the sides. To promote entrepreneurship, availability of credit and balance interest stakeholder, including artists. So where is the word liquidation here coming? There is no liquidation at all here. See, where is the word liquidation coming? It only say insolvency resolution of the corporate person only it says. You can't see the liquidation word at all here. See, that too after they brought in this word after they brought in. But the object of code does not speak about liquidation at all, because the whole aim of the code is to give resolution, not to liquidate and sell the company. That responsibility itself is not given by the code. What the code says is, as a RP, IRP, once they get appointed, you manage the affairs, see that resolution is coming out or not, see, and you give out the offer, get the resolution plan, present before the wisdom of COC, let the COC take a decision, then present before the NCLT, take the approval. So just the law says to act as a mediator only, not to appear before courts as accused, not to appear before the court as the, as a respondent, in many cases as a defaulter or non-filing of return and not doing certain things. No, not like that. Court doesn't provide for. So court does not give that authority to this is RP and liquidator. Court wanted RP to manage the affairs. No doubt, court says to comply the provision, that too through an amendment it came. It says RP shall be responsibility, no doubt at all. Complying the requirement of law. See, there need not to be any specific provision on this. Suppose the RP want to register a land without complying the requirement of Registration Act, Stamp Act, Transfer of Property Act, he can't register the property. If suppose something the RP wants to do to manage while managing the affairs of the company, without following the law, RP cannot do. And there need not to be a mandate on part of the RP. But still law gives a mandate, because while managing the affairs, question should not come that you are not a MD. Who are you to do this? Question should not come. That's the reason the law went on to amend. The code, the lawmakers went on to amend the code, giving a responsibility. Because tomorrow the question should not come. Who gave the authority to comply the law? Means to do certain requirement under the law. You are only there to manage the affairs. But to manage the affairs, whatever is required for complying the law, it is the responsibility of the RP and IRP to comply. That's what the code says. Can you say similar provision for the liquidator? Can anyone you here? Almost 22 is here. 22, 23, right? Can anyone show similar provision for a liquidator during the liquidation process? Can you show? Come out. Say something. Say something. You are all acting as a liquidator, no? Just answer this point, no? Just share your views. You have similar position during liquidation. At least say yes or no. Or you don't know whether provision is there or not. Can I take it that way? You don't know whether this provision is there or not in the liquidation process. I know, without knowing that we are not practicing. After knowing all the provisions only we are practicing. Just tell me whether similar responsibility is given to liquidator or not. I'll take you through much more responsibility, complications, and other issues. I have a lot of case laws to share, against income tax department, GST department, against many other matters to protect the liquidator and RP. Okay. Okay. We'll have a tea break. Again, we'll come back and we'll discuss. Okay. By then, you think through whether similar provision is there or not in liquidation. Okay. We'll go for break for 10 minutes. Okay, we'll start. I'll share this screen again. So were you able to find any equivalent provision? Okay. I'll quickly move on with the next one. So there is no provision. If there is a provision only, you can find out. No, otherwise, how you can find out? There is no equivalent provision. See, all you have to understand what I am trying to convey here. See, all I'm trying to say here, the IRP RP has given a limited, role of managing the affairs of the company and find out a solution to revive the corporate debtor. This is the role of the RP, IRP under the code. Whereas in case of liquidator, even the liquidator is not given a role of managing the affairs of the company because liquidator role is to get a claim, collate the claim and admit the claim or reject the claim. Okay, and find out the value, then realize the asset, come out with the e-action, realize the asset and distribute the money as per section 53. So this is the role given to the liquidator under INB code. Nothing more than that. Here, I was telling you section 17 makes it clear that what is the role of RP, in managing the affairs of the company. What is the role of the IRP? IRP is responsible for complying the requirement of under any law for time being on behalf of the corporate debtor. Same continues because the same responsibility continues with the RP also in managing the affairs of the corporate debtor, because here the responsibility given to the RP, whatever the responsibility given to the IRP, same responsibility continues to the RP. So there is no second opinion on that. That responsibility of the IRP continue to be RP. Okay, because the RP shall exercise powers and perform the duties as are vested and conferred on IRP under this chapter. Okay, therefore there is no second thought that what are the responsibility RP has got. Whatever the IRP has got, same responsibility RP also got. That's even in compliance of the provision of any law, whatever the responsibility given to IRP, same responsibility given to RP also. This is important thing that we need to understand. Okay, here when I take you through to, I'll tell you why I'm showing all this to you. Okay, because there are cases filed by department against liquidators. That liquidator has to file GST return, liquidator has to file income tax. One of our friend also said they've got a return. Any of the participants here has got any assessment done during the CRP or liquidation? Assessment under income tax or GST, any assessment was done? Any experience that assessment was carried out during the CRP or liquidation, any one of your cases?
PF authority generally.
Sorry. You can reduce your volume. Yeah. Sorry.
PF authority generally make assessment of their claim during the CIRP.
Okay. No, they've done assessment itself during CRP or
During
they
CRP.
started and continued?
During CRP, initially they will file the claim, and then after that their assessment, they revise their claim.
No. My question is that whether assessment commenced during CRP or assessment already commenced and the continuation only is carried out.
Assessment already commenced and it is continued during the CIRP period.
Okay.
PF authority specifically.
Okay. That means before CRP itself, the assessment was commenced, correct?
Yeah.
Correct. So will that assessment, okay, let me again take you through to that. I'll put this question because some of our other friends also must be having it, but anyway, they are not coming out with that information. Since been shared, I'll ask you this. See now, will this not be continuation of proceeding against corporate debtor? Will this not affect that in assessment which was commenced, carried out? Will this not affect? Moratorium will not affect?
Yes, it affects, but generally PF authority continuing their assessment.
Generally,
They call the meeting and they call the RP IRP for the meeting for their assessment.
no. Can they do that only? I'm asking because continuation
No,
of
it
proceeding
cannot
also.
be it cannot be done in view of the moratorium under section 14. Yeah, but
That's what I'm
generally,
asking.
yeah,
That's what I'm saying.
yeah.
How can have they passed order during CRP assessment order? Have they passed?
Assessment order means they generally demands that these are the PFU and certain. They
Demand
mention
cannot come here.
certain Supreme Court judgment also. Yes.
Yeah. I'm
Hmm.
asking. No, that is there. I'll tell you. The
Yeah.
judgment is there. In fact, I got in my own case, I got demand order in means rejection of demand of income tax. In my own cases, I've got order from Honorable NCLAT in my favor. Okay, against income tax, I got an order. So, quoting the Supreme Court judgment, I'm not asking that. I'm just asking you whether any assessment as order has been passed. That only I'm asking. You are telling about ABG shipyard so order only you are telling, right?
Yeah.
APG shipyard order, which that's why I'm saying I also got order in my favor that the income tax department.
हाँ जी चिराग
Okay.
ठीक है
Sorry. Sorry, can you come on? No, I'm asking, suppose the assessment order itself is passed during CRP and liquidation. Will it be valid under law only? The question I was wanted to put.
No, it is not valid.
Sorry.
It is not valid.
It is not valid, correct?
Yes.
But still they are completing the assessment order. They are issuing the assessment order. They are issuing the demand notice. They are giving the claim and demanding money from liquidator, or they are filing the case. Correct? They
Yes.
are both GST and income tax. They are filing the case. Okay. So in your matter, what happened? What is the demand you got in your favor?
No, it pertains to the PF authorities and they revise their claim
Okay.
on the basis of assessment.
Correct. Oh, so that then you accepted the claim, admitted the claim.
No, it was not accepted and because it was made during the moratorium period.
हेलो
Yeah, that's what. Whether you admitted the claim only, I'm asking. Subsequently, they given a claim, right?
Yes, yes.
Okay. Now I'll
हाँ जी
I have few cases. I will tell you whether it can be.
जो पॉइंट है मेन वो तो यही है इसके अंदर कि जो पहले जो आउटस्टैंडिंग था दैट वाज 400 एक सेकेंड
Is this?
इट वाज 448.98 करोड़ जो आउटस्टैंडिंग अमाउंट ऑफ फैसिलिटी था अब जो आपकी एक्सप्लेनेशन है आप ये कह रहे हैं कि आपने 448.98 करोड़ के बाद 125 करोड़ का एडिशनल विड्रॉ किया जो कि जो सैंक्शन थी बट नॉट विड्रॉन लिमिट थी अब और आप साथ में ये भी कह रहे हैं कि वो जो आपने 125 करोड़ निकाला वो आपने क्यों निकाला आप लिख रहे हो कि द बैलेंस सैंक्शनड बट अनविड्रॉन पोर्शन ऑफ द फैसिलिटी इज रिक्वायर्ड टू बी अप्लाइड टुवर्ड्स सेटलमेंट ऑफ ईफीजी ट्रेड पेबल्स pertaining to the construction of the project. These payables form part of the approved project financing structure. अब आप उसमें लिख रहे हो कि the proposed refinancing of 670 crores is structured to comprehensively address the existing debt obligations, that is 48.98 crores plus 125 अगर वो आप कह रहे हो तो construction linked liabilities and reserve requirements.
Okay, sir, you
अब
are
जब आप proposed application
Yes, sir.
दिखाते हो funds का तो settlement of EPC
Okay,
trade
sir.
payables तो आप वो under 25 से अलग दिखा रहे हो, 66 करोड़ का आपने अलग दिखाया है. और सेकेंडली एक आपने एडिशनल लोन पहले आपने अपनी एप्लीकेशन ऑनलाइन एप्लीकेशन में देयर वाज नो एडिशनल लोन. अब जो आपने एप्लीकेशन सबमिट की है दोबारा आप जो अपने रिस्पांस सबमिट किया है उस
Chadda, sir.
Are you getting my voice? My God.
Yes, sir. Yes, sir.
In between, somebody is literally completely they were going through their proposal. Keeping the session live. See, now coming to the moratorium, see why I wanted this to understand, because there are a lot of cases are there and which gave ruling or orders against the government department, against income tax and GST. In fact, I myself got a favorable order in both in income tax and GST and all. So there are many orders are there. So why I am saying this, filing of return, the time and again I am hearing, even my own experience, and I even a few of my friends also said department is insisting filing of return, both income tax return and GST return, all are compulsory during liquidation. Is it so? Is it that it's a duty of the liquidator to file returns also during the liquidation? I wanted to take you through in that. Because one of the matter I heard that the refund they were not able to, they are not giving the refund of money for want of filing of return by liquidator. This is happening in many matters I am hearing. So is it so that mandatory on part of the liquidator to filing a return? That see, is that the additional obligation given to liquidator in addition to the responsibility given under section 35? See what section 35 says. I'll take you through section 35, which says, sorry, right. These are the powers and duties of the liquidator. So basically, to understand what is the powers and duties of the liquidator, it is just saying, in fact, this only I even listed in my PPT also. In fact, I wanted to show, I'll show in the PPT also in this. These things, okay, now, so this only I wanted to say, generally the liquidation, when it is getting, either the adjudicating entity does not receive a plan or plan is rejected by AA or committee itself is resolved to liquidate. Okay. Or copy debtor, if they contravene, then also liquidation comes. That these are the process which I wanted to tell: admission and determination of claim, then appeal on the claim under section 42, then consultation, then verification, all that is good. Then professional allotment, whether it is there or not, avoidance transaction, we need to see. These are the basic things generally we see in liquidation. Okay. But here, you see there are few powers are given under liquidator. What are the powers are given? That too, subject to the direction of AA, the liquidator shall have powers and duties to, one, verify the claim, take custody of the thing. Here, this only I was raising the question. Under section 17, I was showing the responsibility of IRP and RP is to also to make sure that they are complying all laws to comply the provisions of the law. Means whatever the law, applicable law, to comply the process. In fact, that given additional responsibility to IRP and RP. If you see the powers and duties of the liquidator is given a very limited power, like to verify the claims of all the creditors, to take custody of the control of the asset and evaluate the asset, to carry on the business for beneficial liquidation. That too only for liquidation purpose, they wanted to carry on the business of the corporate debtor, not for maintaining as a corporate debtor as a running concern. Okay, and also to sell and movable property or actionable in liquidation by public action or private. So these are the important powers and duties given on part of the liquidator to carry on and to draw and accept and to use the official name. All these are the powers given to obtain professional assistance from any person, appoint any professional, then invite claim and settle the claim. Even to settle the claim and to same way to institute a different any institute. In fact, here liquidator with the direction of the supervision, with the direction of the adjudicating authority, the liquidator to institute, or they can institute depend any suit or prosecution, any proceeding, whatever may be. He can't on his own do. Then to take a permission from AA, okay, to initiate any. This is also why it is required in case of recovery, not for running the company. It is to recover any dues they may have to institute a suit. Same way to investigate financial affairs of the corporate debtor to determine undervalue. This is very specifically to investigate the financial affairs to determine the undervalued or preferential transactions. Here the question comes, few of the companies I heard investigation means the inspection notice has been given by Register of Company MCA, Ministry of Corporate Affairs, to investigate or to inspect the records of the company which is under liquidation, okay, which is under CRP is understood. Is it permitted to initiate a inspection or investigation by MCA? Because here the power is given to liquidator only to investigate financial affairs of the corporator to determine, that too very limited scope is given to determine the undervalued or preferential transactions. But here, I heard a few of the matters, the MCA is giving a notice to initiate inspection under section 206 of the Companies Act. Have anyone has encountered here? Anyone has received such notice? Any of the participants? Let's discuss that also, whether it is possible during liquidation or not. Otherwise, you have to encounter that difficulties also. Few of the companies, I think they've inspected also, I believe. Few of the companies, they issue notices and contested by a liquidator also. Have you come across any such thing in your case? Any of the participants? Have you received any notice from MCA or any other to commence any of the inspection or investigation kind of thing? Have you encountered? That means you are not done. You are not encountered. You are blessed to not to get any notice. Oh, okay. But do they have a power to do that? Do MCA have a power to, does they have a power to inspect under section 206 of the Companies Act? Initiate any investigation and inspection when the company is in the liquidation? Can they call for information for the purpose of inspection, initiate inspection, investigation? But here the liquidator can do, because since he has got a records, he has got a duty obligated to find out undervalued preferential transaction, he has to do. Can MCA can do under section 206? Because under 206, the MCA can initiate. I don't know how many of you has handled 206 inspection. Do you have any experience of handling 206 inspection by MCA? So MCA under section 206 can call power, they have a power to call information and inspect book. Do they have the same similar power when the company is in CRP and liquidation? Can they call for information? Have you faced any kind of a issues on getting a notice kind of thing, or getting a detail, seeking any details? On the other hand, did you ask detail from register of companies? Because we have a power to seek information from them. So that means nothing you have done. So your liquidation is very green. You are getting very pleasant experience in the liquidation. Because few of friends shared that they got notice and they were asking whether it is possible or not, whether do the department has power or not. So you have not got, but generally speaking, as we have discussed, I was showing that the moratorium under section 13 and 14 under IBC. Similar way, section 33(5) also is strict. I don't know if you are facing it, then probably you can say that section 33(5) is giving a moratorium that not to initiate any proceeding. Will that be considered as a legal proceeding? 33(5). Yeah. See, under section 33(5), 27 has come. See, when a liquidation order has gone, no suit or other legal proceeding shall be instituted. So that means the inspection should not have been carried out or should not commence. Suppose if the inspection is already commenced before CERP or during CERP, then because it only says that no legal proceeding shall be instituted afresh. The commencement, there is no restriction on that. So continuation is permitted under the code during the liquidation of any proceeding. But initiation of any proceeding is not permitted. There's a legal bar of initiation of any legal proceeding during liquidation. So in case even this is same the case for whether it's a notice from MCA, whether it is a notice from Income Tax Authority, whether it is a notice from GST authority or any authority for this matter. Because in fact, I would have received a notice from all authorities in India. So it's not that I'm just telling for reading books. Okay. In fact, I got a notice from almost every authority in India. Okay. During the liquidation period, I'm saying. So do they have the power? And how the notice has to be dealt with? These are the things that I thought I should discuss with you. In case if you would have entered, suppose if you would not have encountered, then what is the use? Anyway, you are happy without those notices. Then enjoy your pleasant liquidation notice without notices. Okay. If that suppose you got notices, then you should know how to deal with that. Then you should have a rulings to deal with that. There are many rulings are there. In fact, I'll share you little later those rulings. What are the difficulties? In fact, what are the things that we need to understand from this? Very important. Here I was telling about financial investigate financial affairs of the corporate debtor and underwriter transaction. Any idea about avoidance transactions? Have you filed any application? Any of you here? Have you filed any application section 43, and 47, 48, and 66? None of you has filed. None of you have got a experience of filing an application for avoidance transaction?
Yes, filed under section 45 and 66.
Yeah. What is the relevancy or difference between 43 and 66? Is there any difference between that?
Under section 45, it is undervalued transaction, and under section 66, it is fraudulent.
No, that's what I'm saying. 66, you got two different things. That's why I'm asking you.
Yes.
It gives a two different remedy, right?
Yes.
66 gives two different remedy. I can show you a PPT on that, right? Yeah. See? This is for avoidance transaction. So see, when you investigate, these are the things that we need to, as a liquidator, law empowers, the code empowers the liquidator to do a financial, investigation on the financial affairs. Where, to identify financial, irregularities. That's the real purpose, where it empowers the liquidator to do the investigation on the financial affairs. In that case, then these are the things that we have to see: professional transaction, undervalue transaction, exogenous transaction, and fraudulent transaction. Here, the very important difference one we need to understand. There are 6 types transaction is there. As I was see here, the very important thing that we need to understand. Regulation 35A, you all know that it has been introduced much later after introduction of the code. Section 30, Regulation 35A of CRP regulation has introduced, wherein it says before, by virtue of an amendment in 2018, it brought, whereby within 75 days, RP to form opinion on preferential and other transaction. Same way, the RP to make determination within 115 days, and the same way the RP to file an application within 135 days. So these are the purpose of investigation is that it is not only during the RP, during the CRP, this investigation are to be done on the financial affairs of the company. Even as a liquidator, it can be done, because the section 66 empowers during the liquidation also the liquidator to do the investigation of the financial affairs of the CD and file necessary application under section 66. So we need to understand difference between the application that can be filed under section 43 for professional transaction, and under section 45 and undervalued transaction, and under section 50 for exaggerated credit transaction, and 66 for fraudulent transaction. So these are the difference that we need to understand. Preferred transaction, we call it avoidance transaction, preferred transaction. This is very important, is that 43 talks about the preferential, 45 talks about undervalued transaction, then 50 talks about exaggerated transaction, then 66 talks about fraudulent transaction. This is a very important difference that we need to understand when we are getting into the investigation of the financial affairs of the corporate debtor as liquidator during the liquidation process. So these are the few things on an avoidance transaction and FFA. We call it a FFA transaction. Here, very important thing in professional transaction is that the liquidator and the social media, during the liquidation also, the liquidator can form an opinion whether any professional transaction took place or not. Okay, during the liquidation period also, the liquidator has got a duty to make sure that none of the preferred transaction, avoidance transaction took place in the corporate debtor. Here, very importantly, it has to be seen that in case of related party, the look back period is 2 years. In case of other than related party, the look back period is 1 year. So these are the orders that can be passed under section 43 by the code. The code can require the property can be transferred. All this is there. It's only a reproduction of the section 43 under INV code. So same way the orders in case of preferential transaction under section 44, what are the orders can be passed, all that is there. Same way avoidance of the undervalued transaction. We need to really investigate the financial affairs to make sure what are the transactions are undervalued transaction, and how to make sure that these transactions are unearthed and an asset application is filed with the NCLT by liquidator or resolution professional. So all this is possible during the CRP as well as liquidation. And this is an important duty casted upon to RP and liquidator. The same thing is applicable. The 1 year look back period is applicable in case of non-relative. In case of related party, the look back period is 2 years. Same way in case of undervalued transaction, I was referring here. And the adjudicating authority, in fact, after making an application, now the adjudicating authority will make sure they can pass any of the order of restoring the position, how it was. Even they can, in case if you fail, they can initiate a suppose the IRP or RP or liquidator, they fail to file an application, then they can even order for the disciplinary proceeding against the professional who is failing the duty. So the order of AA under section 45, it can also require the property to be transferred back, or can release or discharge, or require any person to pay any sum, or require pay such consideration as a thing. Same way, section 45 vis-a-vis 49. Very important difference we need to understand. Transaction defrauding creditors. This is a bigger difference in that. For keeping the assets of the corporator beyond the reach of the person who is entitled to make claim. Same way, in order to adversely affect the interest of such a person, the adjudicating authority in such case, they can pass an order restoring the possession back and protect the interest of the person to bring back the original possession. These are the important difference between the section 45 and 49. Both pertains to avoidance of the undervalue transaction. So presence of the motive is not here. We need to, a subtle difference we need to understand between section 45 and 49. These are the real challenges when you are identifying, when you are finding out, when you are investigating into the financial affairs of the corporate debtor. What are the things, the real meaning, the words exorbitant, usurious and unreasonable? All this is we need to understand. We can equate with the word called exorbitant. These are the, what are the transactions can be considered as exorbitant under 52. Require corporate debtor to make exorbitant payment, and the same way certain credit transaction also can be treated as a exorbitant credit transaction. If it is taking place, if it took place within 2 years preceding the insolvency commencement date. In case of a related party, in case of non-related property, same thing. 1 year period can be reckoned. What are the orders can be passed is another important here. They can, the AA can pass an order to restore the position, set aside any of the debt on because of the created on account of exorbitant credit transaction, modify the terms of transaction, require the person to repay the amount. All this power is given under the section. All this can be excised by the AA. Same way, section 66, fraudulent trading and wrongful. This is very important to note it down. Even it's very specific. If during the CRP or liquidation process, if it is found that any business of the corporate debtor has been carried on with the intent to defraud creditors of the corporate debtor or of any fraudulent purpose, the adjudicating authority may on application pass order that any person who are knowingly party to the carrying on the business in such shall make liable to such contribution. This only I wanted to explain to you. Here two different things are that we need to note under section 66. What are the two different things that we need to know? Two different scenario is contemplated under section 66. It is not like any other section. See, if during CRP and liquidation process, it is found that any business of the corporate debtor has been carried on with the intent to defraud the corporate debtor or for any fraudulent purpose. So that either it can be with the intention to defraud the creditors of the corporate debtor, or it can be for any fraudulent purpose. Then the AA may application who were ordered that any person who are knowingly party to carry on the business in such manner shall be liable to make contribution. So here it's very important that the two different can be for fraudulent purpose or with intent to defraud. Fraudulent is a wide term. I don't know whether you where to take a definition for fraud. Again the question comes. Fraudulent, what can be deemed as a fraud under Companies Act? We need to refer Companies Act because there is no definition under Insolvency Bankruptcy Code to define what is fraud. Then we need to take a clue under Companies Act. Where to take a clue under Companies Act? Any idea of the provisions of Companies Act? where to take, which is a fraud? Any idea on the Companies Act? Because there is no definition given under the Insolvency Bankruptcy Code. The fraudulent, anything can be deemed as a fraud. Because here defraud creditors is one and it says R. So it can be either one. Both need not to be satisfied. That means fraudulent purpose. What is that fraudulent? What can be deemed as a fraud? Unless we understand what can be deemed as a fraud, how to investigate and understand this particular transaction is a fraud? It's a real challenge that a liquidator will have when they come across a transaction, financial transaction, during the liquidation process or even CRP process, whether the transaction is done for fraudulent purpose or not. When the if a RP or liquidator has to they have to deem a particular transaction as a fraudulent transaction, then they have to test the transaction, means they have to apply a certain parameter and test whether it is a fraudulent transaction or not. How to test it? That then they have to refer the provision of Companies Act only. What are the provisions of Companies Act? I will show you, just see. Because there is nothing to deliberate for you. So you can at least you can try to understand what I'm saying so that it will be useful to you. When you handle it, that time you may not get idea. See 447. That defines what is fraud and fraudulent. Then we need to take help of Companies Act only to understand what is fraud and fraudulent. Okay. Punishment for fraud. What is fraud? Is defined here. Yes. So fraud is defined under Companies Act. Okay. What it says, in relation to the affairs of the company or any body corporate, it includes any act. It's an inclusive definition. So that means this is not specific. It is very inclusive. So it includes any act, omission, concealment of any fact, abuse or possession committed by any person, by any other person with the connivance in any manner with the intent to deceive. My God. So much to cover. It's very wide. That means any transaction can be brought within the meaning of the fraudulent transaction when the element, any of this element is present in the particular transaction. This is very important to note. That's why I'm showing this, because it's not that easy to understand and convince the court, because we need to convince the court that the transaction is a fraudulent transaction. Just because of we got some information, we can't say that simply say that this particular transaction is a fraudulent transaction. No. You need to satisfy why it is deemed as a fraud. Why the liquidator or RP and deeming it as a fraud. That means it need to satisfy certain elements of the fraud. What are those elements on that we need to take a clue under the provisions of the Companies Act? What is fraud? The fraud is nothing but any act and any abuse of position, okay, concealment of any fact, all that is deemed as a fraud under the Companies Act. Because what is deemed as under the Companies Act is applicable to the company, which is under the liquidator or under CARP. So then, if any of these element is present, because everything with the intent to deceive, it is separated by comma. So it's not that all these elements should be present in the particular financial transaction. If any one of these elements is present, that is sufficient to deem a transaction as a fraud with the intent to deceive or to gain undue advantage or to injure the interest of what? See here, very important, to injure the interest of not only the company. It is not that if something is done by the ex-promoter or director to injure the interest of the company. Not only the company, shareholders. Okay, even if something is done, the financial transaction is carried out to injure the interest of the shareholders or company or creditors or any other person. My God, it includes everybody. So that means we need not to specifically restrict to shareholders or creditor. If a particular financial transaction is identified by liquidator in the books of the corporate debtor, that particular financial transaction is carried out in such a manner, taking undue advantage from with the intent to deceive or to injure the interest of either the company, shareholder, or creditor, or any other person, whether or not there is a wrongful gain or loss. So it's not that they should have suffered loss or they would have suffered, they would have earned gain. That's not a parameter at all. So it is sufficient that the transaction by carrying out the transaction, the management of the company or the directors or the promoter of the company, they injured the interest of the company, shareholder, creditor, then it become fraudulent transaction. So this is how we need to make sure. Then if you see, if it is a fraudulent transaction, what court says is different. See the punishment what it is provided under the Companies Act. My God, the punishment is heavy. Punishment of false statement or any false statement shall be under liable under 447. What are the punishment? What punishment is given? Any person who is found to be guilty of fraud for a term not less than 6 months, which may extend to 10 years. So any fraudulent transaction, please understand, it is not only to be dealt under the provisions of IBC alone. It squarely falls under the provisions of Companies Act also. So the liquidator is also duty bound to see that the offender, the wrongdoer, is also taken for task under the provisions of Companies Act under 447. This is also very important. We need to understand, because it's not that simply under section 66 we file something, we are free, our duty ends there. No, our duty is not ending there. I will show you one more thing. What will happen, because once the moment you generally, this is done by ROC by virtue of issue of notice or by doing investigation, ROC does, then SFIO is involved. Okay, but this is the definition I told. Even the first time in Companies Act, we seen such a broad definition in Companies Act. Even the Contract Act defines fraud only particular contract, restricting to particular contract. It is not a wide definition. Okay? This only I was telling you. What is fraud? What is the penalty? So imprisonment up to 10 years. So why I am showing this is, there's a reason behind it. Section 468, which gives a bar in taking cognizance of offense after lapse of the limitation period. If the offense is less than 3 years, the person can take advantage of section 468 of the CRPC. Okay, but here I was telling you the period of imprisonment can extend up to 10 years. That means it's punishable up to 10 years. Therefore, the limitation benefit itself is going away. So that means the moment fraudulent transaction is found in a corporate debtor books by the liquidator, it is a serious thing that we need to look into. It is not simply we file an application under section 66 and relax ourselves. No, it also percolate into under 447 and as I was referring 448 and 449. All these sections has to be considered and see that the actions are taken against the wrongdoer under Companies Act, not only under the IBC, And also, of course, under IBC, there's a separate remedy is given under section 66 where they have to contribute. Suppose if it's a fraudulent purpose, then contribution alone, returning the money alone is not a remedy for that by the promoters or directors. So what is the course of action? So course of action is the action, punishable action under Companies Act. So here, very importantly, as I was referring, 447 imprisonment is up to 10 years under Companies Act. Therefore, the protection which is available, the limitation which is available under Criminal Procedure Code will not help, will not come to the rescue of the person. If it is a offense punishable less than 3 years, then they will always take a limitation as a protection. Anyone to come out from the criminal proceeding. But here, this is a very important thing that we need to understand. So that's the reason I'm very particularly I'm showing this particular portion of the law. Okay. Because when you read it in the act, we don't we never get connected to that. That's why I thought I can took it my PPT on that. Okay. So this is the very important thing that we need to see when a liquidator files an application or when they find a fraudulent transaction under section 66. Now, if you would have filed any application, I think you would have encountered challenges. Then at least you can really appreciate what I'm saying. Otherwise, it's very difficult to connect with that. But of course, you will be getting in future also. Yeah.
So can I ask a question on section 66?
Yeah, please.
Regarding section 66, there is a judgment of Honorable Supreme Court in Glokridge matter that transactions involving third parties cannot be prosecuted under section 66.
66, okay.
So all persons other than directors or partners of the LLP are treated as a third party.
Okay.
So can you throw some light on that judgment that in case a transaction was entered into with some...
I'm telling that the directors are still connected in the process. I never exclude a director at all, promoter, ex-promoter at all. Because I was telling that only their powers are suspended. They are still connected with the affairs of the company. They are not third party.
That is okay. But say in case there was some fictitious transaction for sale purchase of goods between the CD and some Mr. X, who is a third party as per Supreme Court judgment. There was a direct transaction between two parties. One is CD and another is Mr. X, who is a third party as per Supreme Court judgment. Then how we can pursue that transaction?
On behalf of CD, who is representing?
Sorry?
In the transaction, the transaction what is contemplated taken place, someone has represented for CD, na?
Yes, I am for CD now as a liquidator.
I'm saying the time when the transaction took place, I'm saying.
Directors were there, directors.
Then they are the answerable only, no?
No, only directors are answerable, or persons who is a beneficiary of that transaction could not be prosecuted.
No. Here we are not here to make sure that the third parties are punishing. Okay. Here as a liquidator, I was showing investigation into the affairs of the company to see whether the management of the company has done it properly or not. We are not going to whether the third party is right or not, what is the intention of third party. That's not our prerogative at all. Our prerogative is that whether transaction is willfully carried out by the management of the company to defraud the creditor or fraudulently by the management of the company. Okay. Our botheration is not that whether third party is supported or with the help of third party. That's not our thing. The transaction whether carried out with the willful intent of the management of the corporator or not. If it is willful intent for fraudulent purpose to defraud the creditors, then it falls squarely under 66 and the action can be taken against the management. Here, third party automatically will be drawn, of course, subject to the orders given by the Honorable Supreme Court. I'm not getting into that. I'm
But
saying
subsection 1 says that directions can be passed against any person. It doesn't restrict the only to director or partner.
no, that's what I'm saying. See, any person should not have got affected. Here, what I was referring in the Companies Act, I'll show you the provision again. When you read carefully what it says, it is not that the affected person should be company, shareholder, creditor. Even any person gets affected also, then also it can be treated as a fraud. That only is saying. Committed by management of the company in relation to the affairs of the company.
That's okay. But can clawback order can be given against the person with whom transaction was entered?
Oh, that's
That
what
is
I'm
the-
saying. I'm saying let us not travel to the third party. Here, let us restrict to the management of the corporate data. Management of the corporate data has carried out some transaction. Correct?
Yes.
With the knowledge they have carried out, whether as a ex-promoter or director. Of course, director only is authorized. Many of the company promoters only directors. Okay, in very few companies only shareholders are different and the directors are different. Correct. Then too, if with the influence of shareholder, if a director would have done something, then also directors are liable. So here, what we are focusing is the management of the company who has done some financial transaction in a way defraud creditors, interest of the creditor or fraudulent manner. And of course, the transaction means it has to naturally happen with the third party only. Any transaction will naturally should happen with third party. Okay, the other party will be an outside fellow only. But here, what the law gives a responsibility is that just see whether management has done really with that intent or not. With that intent, then file application under section 66. Then automatically the provisions of Companies Act also will fall in place. Means whatever the action has to follow, it has to follow. Because it is the transaction contemplated when the company was in operative. So just like that, ministry or ROC or RD cannot excuse. Since the company has come in the CRP and liquidation, the director who willfully has done some transaction to defraud the creditor, they cannot spare that director or ex-promoter if they willfully done it. Just because the company has come into the liquidation, because it is done willfully when the company was in operation, not during liquidation. Therefore, management only is our focus, not the third party.
Practically, ROC or RD is not taking any action or on the complaint filed by liquidator. They simply says that go to NCLT.
They have to do. See, it is sufficient. The ROC RD is getting knowledge about it. In fact, Indian Penal Code is very specific. Any person who is knowledge about the crime itself has to take action. Knowledge about on a crime itself. After knowing a crime or fraud, anything, if department is keeping quiet, then department is taking a risk on that. They don't need any order for that. Knowledge about the crime or fraud itself is sufficient for department to take action.
So what's your final take on section 66 on any order against any person? What is the essence of any person? That was the only my query.
That's what I'm trying to say here. Here, the order keep coming from adjudicating authority to contribute to the assets, correct? So
it is in the fourth line in subsection 1. Any person is there.
Exactly. But here, what I sorry, can you repeat again?
My query is that whether NCLT can pass order under section 66 for contribution in the liquidation estate against fraudulent transaction against any person, because in fourth line says that any person, direction can be given to any person, not limited to director only.
No, they have to claw back the means they have to get back the asset, no?
Get back the asset from the person who is a beneficiary, whether he is a director or not.
Yes, they have to get back the assets, or if there's no possibility of getting back the asset, they have to tell the management to contribute. Means the director who has done it, they have to tell the director to contribute to the asset. Either way,
Only-
it has to be compensated to the
Only to director, not to the person who benefited from it.
I don't think they can pass an order against third party. That civil court only has got a right.
That's
They
the
can get the
Golopris
asset
judgment.
back. They can get the asset back.
Yes.
They can get the asset back. Okay, as long as it is related to CD, as long as the asset is related to the CD, the NCLT can pass an order to get back the asset. But they can't pass an order directly against the third party. Okay, which is not to recover some money kind of thing, because then it goes to this power of civil court for recovery of money from third party. Correct? Then in which case they can recover the property or whatever gone out of the corporate data, they can recover. They can put the original position. That's why I was showing, we can restore the NCLT can pass an order to restore. See, I was showing a lot of the thing here. No? In many of the provisions, many of the sections, the NCLT can pass an order to restoring the position. Restoring the position as it existed before such transaction.
Okay.
Yeah, very much is there. That power is there. They can restore the position. For that, what is required? Anything taken out from the CD, they can pass an order to restore it. That power is very much given to the NCLT itself. They themselves can pass an order. See, in every section it is given.
But similar wording is not in section 66. That is missing in.
Okay. See, that's the idea is that the contribute to the asset means it can be any manner. Okay, it can be any manner. See, even if you see section 66, what I was showing, see, here I have not showed you full provision. See, you see here, what can be done is given here. The adjudicating authority may by order direct that a director partner shall be liable to make such contribution. Okay. And if before insolvency commencement date, such director partner knew, that means knowingly. Okay. And there is no reason to say. Same way, and if such director partner did not exceed due diligence. So they can pass an order, make them to contribute directly, the directors.
Actually, subsection 1 is limited only for directors, and subsection 1 is related, even covered, any person is covered in subsection 1. That is the difference between two sections.
Yeah. See here, if you see subtle difference, which I was showing you.
Subsection 1 covers any person.
Yeah. See, if found a business corporate has been carried out with the defraud of creditors or for any fraudulent purpose. Okay. On application of the RP, pass an order that any person who is knowingly party.
Any person. There is any person word is subsection 1.
Any person who are knowingly parties to the business settlement shall be liable to make contact. Okay, so they can, that's what I said, they can get back the assets whatever gone out of the CD, or they can ask to compensate.
To any person.
Yeah, that's how it, see, law empowers them. It is up to the NCLT to, make use of that power. Okay.
But Lokri's judgment is saying something else.
It is diluted in the second one. If you see, it gets diluted in subsection 2.
But these are two separate subsections, sir. If we read subsection 3.
That's what, two separate sections.
Yes.
But if you see that here very specifically it says on application made by RP during CERP it says. Here if you see, it covers both. Okay. Here both, liquidation process.
Yes.
CERP, both here covers. That's why I'm saying. Here, this situation covers only CERP.
Yes.
That's why they are directly saying director and partner of the CD, because they are running the show. They are running the show that time. Okay, that's the difference. So, in fact, that case to case things differs. We can't make a standard rule or principle. It is up to the NCLT how they are subject to the direction of the.
Thank you, sir. Thank you.
They are doing it.
Thank you.
Yeah. So now coming back to this, so these are the things which I was showing you, that what are the responsibility, the investigation, and so these are the specific powers given. So these are the real challenges where the liquidator, while executing the, their powers and responsibility, what they supposed to deal with that, they have to properly carry out the powers what is given to the liquidator, because liquidator is given a very specific power. That's why I wanted to specifically show this. Here I was showing this here to add one more point. In any one of these powers and duties of the liquidator, nowhere in this powers and duties, liquidator is given a power or duty or casted upon a power of duty to file any of the returns, okay, to carry out any of such functions, to comply any of the law, very specifically to liquidate and to realize and to settle the claim and to file a dissolution. It gives very specific power to the liquidator during that time to investigate financial affairs. This too, why they give a power to liquidator to investigate the financial affairs? Because the money can be recovered and that can be given to the stakeholders who are given a claim. For that limited purpose only, they wanted to investigate the financial affairs. Suppose the liquidator is able to recover some 10 crores, some 100 crores out of the financial affairs which has been done as undervalued or professional transaction, then liquidator can take steps to recover that money under section 66 what we discussed now, and that will add to the liquidation estate for distribution to the creditors. So this is the additional fund that a liquidator may get for distribution. For that limited purpose, the liquidator is given a power to investigate. So here also, not to give any, file any returns and subject the corporate debtor for the assessment proceeding or any other proceeding. There can be 100 proceedings that can be initiated by the department for the running company. All that 100 proceeding cannot be initiated for the liquidation company under liquidation, because company under liquidation is specifically to realize and distribute and dissolve. Okay, to see that maximum the asset can be realized at the maximum value, and what maximum the settlement can be done to the creditor, and the dissolution is done after settlement is done. So this is the real purpose. But here, completely now things are practically happening different. Every department is asking, the liquidator to do all clerical job. Is it not? Whether you agree or not. Okay. I know many departments are insisting, are sending notices, letters, issuing, letters to the liquidator and RP. At least they are issuing RP since it's okay. RP is doing managing affairs of the company as a running company. There's nothing wrong giving a instruction to the advice to the RP to give some detail or do something, file some return, because it's a running company. They are managing the affairs of a running company. But liquidator is not doing a running company. He is not managing the show at all. He is only making sure that assets are realized, claims are received, and whatever recoverable amount are recovered and claims are settled. The limited function only is liquidator is doing, and liquidator is empowered only to do that function alone. He cannot subject the CD in any of the proceeding, any of the criminal proceeding, any of the civil proceeding. As I was referring that he cannot subject the CD and make his name appearance as a A1, accused 1, accused 2, accused 3. He cannot subject himself as accused. Suppose the liquidator handled 10 cases or 5 cases. You see, just remember how it will look. In all cases, liquidator is shown as accused. That too, now all the courts are not even referring as a liquidator on behalf of a company, nothing. Simply they put X. Mr. X, A1, accused. Not even saying liquidator also there. In many of the matters I'm saying. They simply refer the name and say accused 1. Is it the law says? This is how the law says. No. Law contemplates different. What is happening in practical scene is different. They have to correct themselves. They have to only say the designation. When the cases are listed, they have to say resolution professional of so-and-so company, ABC company, resolution professional of ABC company, liquidator of ABC company. Because liquidator today may be X, tomorrow Y, day after tomorrow it can be Z. There may be X, Y, Z. Any one person can be a liquidator. The name of the person should not be shown as accused or should not be shown as a plaintiff. But here, unfortunately, last 7-8 years, it's happening that way only. We can't help it. Okay. So now, one more thing I wanted to say. Practically, one more thing I want to show. These things, unless we escalate or unless we represent, it won't change. We don't know whose name, whoever the partisan, your name also tomorrow will appear as A1, A2. Unless we represent and say that this is wrong process, what is followed by the court. Name of the liquidator or the RP should not be shown because they are only representing as a court officer, they are representing the CD. And nowhere personally they are representing themselves, whether himself or herself. No person is representing. They are representing as a court officer. In fact, by putting the name of the person in a criminal proceeding, name of the liquidator or RP in a criminal proceeding, they are demeaning the NCLT only. Because the NCLT is also judicial authority. Here the criminal court, they can't put the name of the court officer. That means they are demeaning the NCLT only. Because he is only representing NCLT. He is not representing on his own. So I think this has to be taken little seriously, and represent and see that in future the listing is done properly with the designation, not by.
Sir, good evening.
Yeah.
Good.
Sorry.
कोई बात नहीं सर, हम ना ये वाला ट्राई कर लेते हैं क्योंकि इसमें एनसीडब्ल्यू लोगो भी है, इनका मिल जाना चाहिए अगर एग्जिस्टिंग सेम पे नाम पे नहीं होगी तो। और अगर ऐसा कुछ, हाँ जी,
So you are talking to me?
नहीं वो तो उसमें कोई फर्क नहीं पड़ता ना, वो तो क्योंकि वो तो कोई दिक्कत ही नहीं है उसमें। हाँ, उसमें कोई दिक्कत नहीं है, मैं करवा लेता हूँ सर। और अगर बाई चांस अगर कोई होगा।
Again started. Again our friend has started. So here, see, our friend is again and again is coming in between. So now that's what I was trying to say here. Now we have to escalate these things, otherwise things will not change. Okay. Now another important thing which I wanted to discuss here, the new provision has come in the liquidation regulation. Many of you must have constituted a stakeholder committee, right? Many of you must have constituted a stakeholder committee. After the introduction of the regulation 31A. Today the stakeholder committee is given they have given a power to remove a liquidator, right? Is it so? Whether the stakeholder committee is given a power to remove liquidator?
Yes, of course, provision is there.
Okay. Whether is it right?
Right or wrong, it is happening, sir.
It's happening, right?
And in case, unfortunately, as a liquidator, in case someone wants to get rid from his case because it is not remunerating and resign, then neither stakeholder committee accept it nor tribunal came to help.
So it's a bitter fact, bitter fact.
And if you have any solution to come out of such cases, then share with this.
See here, one side, here 31A is giving power liquidator to remove. That's a
Sub-regulation 6 is there.
Yeah, no, 31A, I'm saying. 31A, the stakeholder committee is given power to remove the liquidator. Correct? Is it not?
Yes, sub-regulation 6 is there.
6, correct. Subregulation 6 gives. Okay.
6.
So they can convene a meeting. If they want, they can pass a resolution to remove. Okay. So now why was
It may be 10. It may be 10 or 11. Sorry. Sub-regulation 10. Yes.
yeah, correct. I've seen. See, I wanted to show you something else. Okay.
Okay.
The advice of the consultants committee shall not be binding on liquidator. Correct?
11 is there. No.
Here it says, this also they said, just to specify, this also said, okay. But here my point is this only, when you are saying it is not binding on the liquidator, okay. See, you say any person who suppose subregulation like 11 empowers the consultation committee to replace the liquidator, correct? So 11 says that consultation committee can replace liquidator and file application. Okay. You tell me when a committee will take a decision to replace liquidator. Just tell me.
Sorry, once again, please.
No, I'm asking. The committee is given a power to propose to replace a liquidator. File application, okay, with adjudicating authority for replacement of liquidator. Correct?
Okay.
When a committee will do that? When SEC committee will do to replace a committee? When they will try to replace a liquidator? Just tell me.
After voting, majority vote is there?
No. In which situation? When they are getting unpleasant situation with liquidator, correct? When they will get unpleasant situation?
Yes, of course.
When they will get unpleasant situation, I'm saying.
It is.
When their instruction is not followed? When their
Yes, definitely. Practically it happens.
correct?
Only
when their advice is not followed, they'll get unpleasant situation with the experience with the liquidator, then they will propose to change, correct?
Yes.
But here, the same law only says the advice of committee is not binding on the liquidator. What I really looking funny only between these two things, because one way it is not binding. So liquidator can take a decision on his own. One other way we are telling to remove a person, same committee to remove a liquidator if they are not happy. Correct? Either one only will work, I am saying. Either liquidator will completely follow consultation committee, correct? And be in the good books of the consultation committee so that he remain as a liquidator. Or liquidator has to come out because otherwise they will remove them. Because if the liquidator is not listening the consultation committee, naturally consultation committee will propose to remove only.
That is happening, sir. That is very much happening.
I don't know why these laws and all, to satisfy whom all these laws are there. And that too, this particular piece of law, if you see, I'll show you, you'll appreciate when I see the provisions of code. See, the code, the provisions of code, what it says under section 35, the liquidator shall have power to consult any of the stakeholder committee entitled to distribution of profit under 53, provided such consultation shall not be binding on the liquidator. So that means the liquidator, he will have a power to consult. Okay, and that consultation also will not be binding on the liquidator. Okay. But today, it is totally gone in a different side. Now, if you don't listen consultation committee will throw the liquidator away.
That's why the total AFA are below 50% nowadays.
Then how you want a code to really to get executed in letter and spirit? Because one-way liquidator wanted to perform his duty as per the code. The other side, SEC, they will be wanting the liquidator to do things at their whims and fancies, whatever they think. Suppose SEC have got 10 members. The 10 members will have a 10 different permutation, commutation, and they will have 10 different views. They will have a 10 different desire. The 10 members of SEC committee will have their own desires. Correct? Because there is no rule which really controls, which really regulates those SEC members. Is there any rule?
That is the basic problem of entire IP fraternity, that we are well regulated, well controlled, and well subject to disciplinary actions, and COC and SCC members are nowhere accountable.
So then in that case, then topic is very much taken care of here. Okay, the topic, how a liquidator will not face a challenge, you tell me.
He will face
only, no.
Yes, he will face, and we are facing, as a liquidator, we are facing the challenge. In case we are not sending minutes of COC meeting or SCC meeting within 48 hours, then disciplinary action follows. But in case they are not voting on the agenda item within even after 2 days or 3 days or 5 days, then there is no question on those COC or SCC members. They have liberty of time, luxury of time.
Good, at least you are strong enough to share all your experience. Okay.
So but I have a very bitter experience, sir. In past 7-8 years, I left this profession after doing my first case in 2017. After getting a very bitter taste, and then again entered in 2019 and done my 4 cases. But now again stuck up in liquidation cases. 4 liquidation cases. I have filed dissolution in 22, in March 22 and May 22. And those dissolution applications are pending as on date also. I am following them.
Good. But law wanted within 1 year the liquidation proceeding to be completed.
Liquidation has, I can conclude the liquidation, but dissolution is to be done by NCLT.
No, that and all you should not say. 1 year, within 1 year you're supposed to complete liquidation.
Yes, that is law. Timelines are for us, na. Timelines for us, not for others.
Then what is the use of discussing 2 hours, 3 hours? That too many of our friends are keeping quiet also, as if they are enjoying the liquidation proceedings.
That's why me and you are discussing, and others.
Enjoying. Okay.
Yes.
Let them enjoy. Okay, no problem. Let them enjoy what is there. When they come, they will handle. Don't worry. Okay, because they are better in handling things. That's why they are.
But that is the pain of not only of my, but of a number of professionals who are stuck up in the dissolution or closed matters. There is not even a single penny is available for expenses, but I have to pursue my case endlessly.
But only I said, no, you are an incarnation of a God. That's only I was referring. No, we are incarnation of the God. That's why the department and everybody wanted without money to run the show, entire thing. Okay?
Yes. And we are still competing to run the show again without money.
I started the session by saying this only. Okay. I started the very session saying this only. That liquidator, unfortunately, expected to be seen as a incarnation of the God by everyone. Okay.
No one is coming to our help.
No, you are a God, no? Why you need help, sir?
Yes.
God. So they think that way only. You are incarnation of the God. You don't need any support from anyone. So you will do on your own everything. You are the incarnation of God. That's how the entire world thinks. I don't want to name it X, Y, and all.
Yes. That's not appropriate to name someone at this form.
Okay. So here I was shocked only by seeing these changes are coming in the code. I know in practice I'm saying, where one way you are giving a rope in hand, the other way the law says that you are completely at liberty to do on your own, but our rope is given to somebody's hand.
No, that rope is used to tie our legs now.
I don't know. Our friends only should answer because they are only peacefully doing the liquidation proceeding. That's why they are not sounding no. They only should give way out. Okay, because they are handling peacefully all the liquidation proceeding.
I think, sir, some sessions should happen on those topics which are troubling to the IP fraternity directly. That pendency of a liquidation matters for years, non-payment of fees. These are the real burning issues.
Yeah, openly in a forum you are sharing that May 2022 you file a dissolution application. Okay.
Yes.
And today we are in 26. Even a
Yes.
dissolution application takes 3 years time.
Yes, it's taking.
3 years time it is taking.
It is 4th year, sir. Next month it will be 4 years.
That's what I'm saying. Then how blindly we are saying that the law is completely taking care of entire control of entire gamut of how law is keeping control. How we are saying that? I really don't understand. And we are talking on our own, and we will switch off and we will move on, and silently we handle our struggles. Correct?
Ultimately, my AFA expired a few months ago, and I am not troubling to even revalidate it.
So here, by bringing this here, one way they are given a power of removing the liquidator, proposing to remove the liquidator. Other side, the law says you need not to follow. It is only a not binding. It's only a recommendative only, not binding. So I fail to understand. If I don't listen, they are going to throw liquidator out. So it is that only finally is going to happen. Then what is a big deal on that? In fact, I have some other thing also to share. Many of the cases, the income tax is saying that no return to be filed, all that. So I in fact collated case law to present actually. So see, these are the case law which has come in favor of liquidator. No, all case laws are in favor of liquidator only. But then too, I don't know, somehow nothing is coming in favor of liquidator, and still the department, taking a liquidator for ride. These are the case laws I listed out. Many case laws coming, these that liquidator has not got a role, In fact, liquidator has got a limited role. Many case laws has come out. In fact, even one important case law which I have to say, that Om Prakash Agarwal case is very, that though it is pending before Supreme Court, but today that's a legal position. What was the case that was come? But nobody want to understand. Conveniently, people want to ignore and move on. What else to do? See, the ABG shipyard case also there. But then too, so much of claims are coming. Even today, lethargically, conveniently, they are filing, all departments are filing their claim after a period of 3 years, 4 years. And there's a Supreme Court order is there, 2022. And they are least bothered. Departments are least bothered. No, I will file a claim. Why I have to bother? Because nobody is there control me. After you are poor people, there are different person is there to control you. Put pressure on you. We don't have any department are free. They don't have any pressure and nobody controlling them. They wanted to see that liquidator and RPs is taken or right. Even in the openly in the case of Om Prakash Agarwal, it is very clearly told. In fact, Honorable Enclat very clearly told. More than this, no clear guidance should be given. For filing a return, financial statement are required to be annexed. Does not assign. See, the code does not assign a duty of liquidator to prepare a financial statement. So for filing a return, for any return, the financial statement are required to be annexed. Unless the liquidator is given that authority, how a return can be filed? In fact, 139 Income Tax Act section 139(11) says, If the return is not accompanied with a financial statement, that return is a defective return. Then two department says, no, you have to filing an income tax return. Then only I can consider return of the refund or whatever it is. For anything, they simply say you file an income tax return. My God. In fact, I can rather show their own income tax appellate tribunal has passed an order. That itself is there. They never bother. Departments never bother. Never bother whether it is their own tribunal or our tribunal. They said we are supreme and nobody can control us. Okay. So we will claim, we will not refund anything. We will pass suspend order against you. We will do anything under the sky. Nobody can question. That is how the department behave. What to do? See, I have their own appellate order, which clearly says that any deposit, any interest earned on deposit should be refunded. But nobody bothers. Income tax is least bothered. They keep saying that you file income tax return, then only I will give refund. Same way for GST also. I have number of GST cases to show you for refund. There are number of cases are there. GST also says, no, I am not bothered. Whoever says I am not bothered, I will say simply, no, I will not refund. You go wherever you want to go. So I don't know. When a liquidator is seen as an officer of the court and seen as a person representing corporate data to resolve the, to resolve and recover, bring a recovery in the proceeding, and is subjected to many laws. Why government department is not subjected to any laws? They have not bothered for neither for the ruling nor for the any acts in the country. I think something has to come out to see that how the RP and liquidator is regulated. Same way, unless the stakeholders and government department are not regulated, at least with respect to the IBC code, I'm saying, whenever matters are coming under IBC code, unless they have a standard rule or regulations, the liquidation process will drag forever only. Like our friend said, it not even 3 years, 4 years, even it will drag 7 years, 8 years. Even we can't dream also, it may drag to 15 years also, because government not bothered, stakeholders not bothered. And ex-promoters, they are happy. Sitting at that place, they are happy. Because nobody is troubling them. Because every case is filed, Mr. X versus so and so, whether it's a criminal court or civil court. No promoter name is coming in there. Why promoter has to bother? He'll also be happy only. Okay. So these are the difficulties literally. I don't know whether you are facing. Many liquidators are facing with my knowledge. So I thought I can share with you. If you have any doubts, you can ask me. In fact, I was collated judgments also to share. But anyhow, these are the predominantly the difficulties that we are facing in the liquidation process. If you have any other queries, you can raise. Otherwise, we can conclude the session. Anjali madam, I have concluded the session, ma'am. I done with my presentation. I can take up the questions if any. Otherwise, you can conclude the session.
Hello.
Yes, madam.
Sir, I have a query in this regard. If a liquidation order has been passed yesterday basis and we want to dissolve the corporate debtor instantly because there is no assets for liquidation, do we have to make the public announcement and all procedure, or we can directly resolve?
Is raised in the previous session also, detailed explaining is given also in that. Actually speaking, see, where the period has to be complied with. Means whatever the compliances in falling within that period, whatever the liquidation regulation says, whatever the code says, within the statutory period, what needs to be complied has to be complied with. But here, anyway, the section empowers liquidator. The COC is given authority to directly liquidate if there is no asset. They can very much authorize the person to file a liquidation application if there is no asset to directly to filing liquidation. The code gives powers to that. Okay. If the COC authorizes, you can proceed.
Okay, sir. Thank you.
Thank you, sir. Wonderful session, sir. Thank you very much.
Let's have some solution. Let's see. Let's hope for the solutions.
Yes,
Yes, madam. Anjali, madam, can we conclude?
Yes, sir. If session is over, then we can conclude.
Yes.
Thank you very much, sir. Thank you all the participants for giving their valuable time
Thank you, sir.
and sharing the
Thank you all.
experience.
Thank you all
Sir,
for.
you are requested to kind.
Sure.
Dhanapal, sir, please share the PPT also.
Yeah, sure, man. Thank you.
Thank you,
Thanks
sir.
a lot for all your patient hearing. See you all. Bye.